Susan Greer, who is our next speaker, was called to the bar in 1973. She has, since her call, been associated in practice with McCarthy & McCarthy in Toronto, in which firm she is a partner and in whose estates, trusts, and estate planning department she practices. Those of you who know Susan most likely know her for her activities with the Canadian Bar Association. She has, since 1973, been a member of the Wills and Trusts subsection and a member of Ontario Council. And she has been Secretary of the Ontario branch and for 5 years, from 1975, a member of the executive of the National Young Lawyers section. Susan has, since her call, been an instructor in the estate administration section of the bar admission course and a tutor in the wills drafting seminar at the University of Toronto Faculty of Law. Susan Greer.
Thank you very much, Marvin. Well, I have been given the topic of recent developments in probate practice. And I felt that certainly from a practical point of view, I would like to cover things that I have found in the past 7 years are sometimes difficult things to locate in textbooks. And they're often things that are not talked about in cases at all. But for the general practitioner and for the practitioner who likes to have practical answers to problems, I am covering 4 topics. When the paper is published, there will be attached as appendices certain precedents, which I am not saying are by any means letter perfect. I'm just saying they might be of some assistance to you if you come across the problem. I have always been one, of course, who's relied on Rodney's book and relied on Morris Cullity's lectures from law school. And I have also relied on Hardy Rideout's very good patience and very good sense of humor in the surrogate court. And one of the things that has seemed to cropped up recently is the question of due execution of wills. Now that might seem to be an old hat topic, and you might say, well, why are we talking about due execution of wills? But in my view, and certainly in recent practice, we have come across these problems because we're finding that people are buying the old stationer's forms. And some of those old stationer's forms are really negligent in the setup of the will. And so we find that testators, for example, are signing these will forms. They're writing their own wills, which is even worse in some cases. I think that there are some solicitors making the mistake of sending wills out for clients to sign without proper instructions. And you know, there is a question that the solicitor really ought to be in attendance when the will is signed by the client. So the question of due execution, in my view, is one that we ought to examine. Section 4 of the Succession Law Reform Act, of course, covers due execution. The difficulty comes when the execution of the will does not fall within the section. There is a legal maxim, and I'm always very bad at pronouncing Latin words, but it is omni praesumenter rita esse acta, which simply means that it is assumed that the requirements of the statute with the reference to the formalities of execution have been complied with. And the maxim in several cases has been stated to be an expression in short form of a reasonable probability and of the propriety in point of law acting on such a probability that the will was executed. Now that maxim was affirmed in the Harris v. Knight case, which is sort of one of the beginnings, and in earlier English cases. And Tybalt in his book sets out the common law proposition that if a will purports to be properly executed and attested, and there is no doubt that it is the testator's will, the court will assume that it was properly executed and attested, although the evidence of the attesting witness as to the execution may not be satisfactory. Now, I think that is a very important point to remember, because often you find that the witnesses cannot be traced. And if the will is simply submitted by the executor to the court for proof in common form, then the court does not inquire into whether it was properly executed or anything about the witnesses. If the testator's signature is proved and if the executor swears, then the grant is issued. Where we run across the problems, of course, is where a caveat is filed or where an intervention is filed, contesting the validity of the execution of the will. And, you know, a will can be signed Napoleon, as long as the person signing it, it's in his handwriting. He might call himself Napoleon. A will can be signed Mother, a will can be signed X. So those aren't the kinds of things we're talking about. The courts have always looked to the testator's intention, I think, when examining the will to see if it has been properly executed. And the cases involving the will form that has been contested have set down a number of legal principles. But in my view, each case seems to turn on the facts. You know, Mr. Sheard used to always say, well, on the one hand, the court must look and carefully examine each word of the will. But on the other hand, the court says we must take a look at the intention of the testator, the surrounding circumstances, and so forth. So in many instances, you know, it really is roulette when you are presenting some of the fact situations before the court. So in certain of the cases, the principle, the legal Latin maxim was followed, and the courts point this out. And in the case of Ree Gardner, where all of the parties conceded that the signatures of the witnesses and of the testator were correct, and even when the witnesses did not ever remember signing the document, the court accepted that the will was validly executed. And of course, this is also the case if the witnesses are dead or forgetful because of age or infirmity. Now, Section 7 of the Act sets out the principles for due execution, and I'm not going to go over those with you. But there have been a number of interesting developments in recent years regarding the will form. We have, on the one hand, two conflicting cases. One is called Ree Bean, and one is called Ree Man. And Ree Bean held that where the testator neglected to sign the will in the appropriate place on a will form, but signed his name on the envelope. You know, some of those old will forms had envelopes. Signed the name on the envelope, that it was not intended to be his signature, and the will was held invalid. On the other hand, you had the Mann case that said where the signature was on the envelope in which the will was placed, the will had been duly executed. Now, there's a 1979 case called Ree Riva, and I think it's an important case because it went against the Bean decision, which was Rodney Hull, by the way, was trying to uphold. And I thought that the case was useful because it involved one of the printed will forms where there's a tiny asterisk out in the right-hand margin. There is no place for the testator to sign. All of the clauses are shifted way over to the right of the page so that when the testator, if the testator has glasses on, looks, the tiny asterisk, and at the bottom it says, testator signs here, but there is no place for the signature. So in the Riva case, the testatrix signed her name in the blank on the front. This is the last will. She signed her name in the attestation clause. She signed her name on the back of the will form, which was a folded form, and she signed her name on the envelope. But she did not sign her name where the asterisk was. And on top of that, the witnesses could not be traced. Great efforts were made to trace the witnesses, and it was alleged by Rodney that perhaps the testatrix herself had signed the names of the two witnesses. The signatures were, I shouldn't say that with Rodney not here, but the signatures were such that there could have been a question. There certainly could have been a question as to the signing. A handwriting expert, Mr. Packard, Royston Packard, was brought in to examine the handwriting of the deceased, examined other documents with their handwriting, examined the handwriting The court allowed the will to be praecipate up to Barrie, where he lives, and his opinion was that it was the 3 signatures were done by 3 different persons and with 3 different pens. And he provided an opinion to that effect, which was submitted to the court, and he was also an expert witness on that. And the judge made, I think, a very, very solid case against these will forms and upheld that the will was validly executed. The judge followed a case in the beginning called In the Goods of Francis Everett. And I think it's important that we look at these principles. 2 things may be laid down as general principles. The first is that the court is always extremely anxious to give effect to the wishes of persons if satisfied that they are really their testamentary wishes. And secondly, the court will not allow a matter of form to stand in the way if the essential elements of execution have been fulfilled. And therefore, the judge, I think, hung his hat partly on that case, and then he went back and he examined other cases which dealt with the section regarding due execution of the will. And he took up a quote which said, "The clear intention of Section 9, which is now incorporated into the new Act, is that within the limits of reasonable construction, the court is to go to all lengths to save a genuine act of execution from being defeated by the formal requirement." Now, I think that is important because, in my view, then, the courts are getting away from cases like the Ree-Bean case that was on a very fine point. The will was held not validly executed. He also mentioned the estate of C.R. Phibbs, a case where the witnesses could not be located, and he upheld the will on the following grounds. There was insufficient space to sign where the asterisk was. There were letters of the deceased in her handwriting, which upheld the very same areas of concern as did her will. In other words, she'd written out almost like a holograph will, but it was before holographs were legal. And the 3 main areas of concern were legitimate. They were charities that she had an interest in, her brother and her niece. And because of the asterisk, it seemed necessary for her to write her name on the back of the will form. It said, "This is the last will and testament of me." And she went to the trouble of getting the form, filling it in, getting 2 witnesses. And in his view, the signature on the back of the folded will form fell within the requirements of the Wills Act. Now, then there has been a recent decision reported in the Estates and Trusts report called Ree-Phillip, and some of you may be aware of it. It's a 1980 case, Manitoba Court of Appeal. And in this case, we again had another will form. And here, in my view, the courts were doing cartwheels to uphold the testatrix's intentions. And I must say, for the gentleman in the room today, it's rather interesting that most of these will form cases are women who are filling in the forms. I noticed this as I followed it through. The Phillip case accepted as a holograph will a will form where the testatrix had filled in the blanks. Now, again, she had failed to sign the will. And the court felt that she had intended using the words in the printed form only as a guide in making a holograph will. And the trial judge held that the deceased had signed the will with testamentary intention and meant it to be her will. No witnesses signed the will. And one of the questions she signed it, but there were no witnesses. One of the questions which the appellate court was asked to consider was whether the printed portion of the will form was essential or non-essential, was formal or superfluous. And the appellate court split on the decision, and I thought the dissent was interesting because you could see sort of the 2 lines of jurisprudence here. The one which sticks to form and the one which looks at the broad intention. And the dissent said, one has to strain plain and simple language to conclude that this document is wholly in the handwriting of the deceased. In order to do so, one must also ignore all the printed material, some before the handwriting, some in the middle of the handwriting, and some at the bottom of the document before the signature. One cannot cast his legal eyes only on those portions which had been written in longhand. It is not the court's duty to strain the plain meaning of words. Now, that was the dissent. So he placed a strict interpretation. But the court, in the majority view, tried to give effect to the testator's obvious intention, which was to provide specific legacies to charities and others, and the residue to be divided between a niece and a nephew. And the majority of the appellate court accepted counsel's submission that the cases of Re-Laver and Sunrise Gospel Hour v. Twiss should be applied, and they ignored the portions of the printed will form. So I came to the conclusion then that the courts seem to be interpreting the law to give effect to a testator's obvious intentions. And I think that this is an important move in probate practice. Now, a second topic that I wanted to cover was the topic of what to do when the testator disappears. And I think this is probably becoming an increasingly complex problem for those people who are left to tidy up the affairs of the testator. Now, maybe the testator has disappeared to Switzerland, where the bank account is, or to Mexico, where the money which he has embezzled is now in place. But I think those are not the usual cases that we have to deal with. We have to deal with the cases where there has been a probable accident, a drowning, for example, a small plane going down and no one locating the plane, someone just simply disappearing, the old riverbank cases or whatever. And this, I think, puts the next of kin and the spouses in a very difficult position. There are really three routes that can be taken in administering the absentee's assets, if we want to call them the absentee. The legislature has provided a statutory method under the Absentees Act, which does not exactly spring to mind when one's thinking of legislation, but it is there in fact. And basically, that allows the absentee's assets to be administered much like a committeeship under the Mental Incompetency Act. It is a committeeship. And if you read the sections of the Act, you will see that the method of administering these things is very similar. The same type of application, the duty to account, and so forth. And if the absentee falls within the meaning of the section in the Act, then the court can declare that person to be an absentee. Now, one of the difficulties I see with that, of course, is that there is no certainty. Does one wait 7 years and then make a court application regarding presumption of death? In my paper, I've referred to a number of cases, but I am looking at the time element, and so I think that I'll just simply say that that is one of the methods, and it could be considered. And the second method, of course, is the surrogate courts method, and I think that this method is a tidier method, I suppose, for winding things up, but can also provide some difficulties. The Surrogate Courts Act, under Section 21, says, subject to the Judicature Act, subject to the Judicature Act, all jurisdiction and authority in relation to matters and causes testamentary lies, of course, with the surrogate court. The surrogate court alone has jurisdiction to make an order permitting an applicant to swear that the person died on or since the date of the disappearance. Now, McDonnell, Sheard, and Hull point out that there is no jurisdiction in the Supreme Court apart from statute to make a declaratory order presuming someone dead. And the presumption is that the person is dead, not really that he died at any particular time or died with or without issue or anything else. There are a number of old cases that deal with the question of remarriage, where people made applications to court because they wanted to remarry and someone had disappeared. I don't think I need go into those particularly, but I want to refer you to a very well-written article in the Estates and Trusts Quarterly by J.C. Shepherd, who canvasses the areas of the law regarding presumption of death. And that's in the 1979-4 Estates and Trusts Quarterly. Shepherd states that the primary jurisdiction for declaring death arises in the surrogate court, for the surrogate court must find on an application for letters of administration or probate that the person is in fact dead. And there was a footnote to that statement comes to the conclusion that the statement in a case called Re Lloyd. Now, I hate to refer you to this because in the paper there are 3 different cases of Re Lloyd referred to, but it does say that only the surrogate court has jurisdiction. He feels that the fact that only the surrogate court has jurisdiction is probably wrong in light of the later cases. I tend to disagree with Mr. Shepherd's conclusions on that point, and I have set out my reasons in the paper. I would suggest that the application under the surrogate court is important because the applicant makes the application so that the applicant can swear an affidavit that the person is dead. In other words, the court is not really deciding that. The court only decides that on the evidence submitted, it will allow the applicant to swear that affidavit, or to make, and therefore, when the application is accepted and the order made, then the executor or the applicant for letters of administration may go ahead and apply to the court for probate or letters of administration so that the estate can be wound up. The court is doing, after it allows the applicant to swear the declaration, is simply accepts then the will for proof in common form. And then if anyone wants to contest this, then of course they have the right to do so. Now the difficulty of course arises when the absentee reappears, because he could find his estate administered and all the assets have disappeared. And Shepherd does point this out in his article. And in his view, and certainly in my view, the law is not clear. I think that the trustee is likely protected by the sections of the Trustee Act, but on the other hand, it also allows the absentee to try and trace assets. So again, we have a difficult position. The third alternative is the procedure under the Insurance Act. And the question of presumption of death often arises in these so-called mysterious disappearance cases where insurance policies are involved. Someone calls you and says, I'm the beneficiary of this insurance, or usually the insurance company calls and says, what do we do under these circumstances? Section 183 of the Act, Insurance Act, gives the Supreme Court, on application to it, the power to infer death of the insured from the evidence presented to it. Section 184 extends this to cover the situation where the person has been absent for 7 years or more. Now, it's of great comfort to the insurance companies if they say to the applicant, well, let's wait 7 years, see if he turns up. And it can become of great hardship to the beneficiary of that insurance policy. And there is no easy answer, I suppose, unless you go by way of the route of the surrogate court provisions, where someone takes out letters of administration or probate, which then the named beneficiary of the policy can present to the insurance company. Now, presumably there's no death certificate, so however, the insurance company might accept that, and you might get around it in that way. Now, the cases point out that one of the difficulties with the Insurance Act application is that any declaration made by the court applies only to that particular policy for which the declaration is made. So it might be appropriate then to give notice to all insurance companies at the same time so that you can deal with it all in one application. And it should also be remembered that the federal government, in its wisdom, has put provisions in other acts which would assist a spouse. For example, federal government statutes such as the Public Service Superannuation Act gives the minister the discretion to issue a certificate deeming a contributor to be dead, as does the Canada Pension Plan Act and the Pension Act, and there are a number of these that are cited in Mr. Shepherd's article. I always find this amusing when I read something like this, and I've been trying to deal with the government annuities branch, where the only asset of someone who is no longer mentally capable is a check, monthly check of $167, which the annuities branch will not pay over to the widow without an appointment of a committeeship. You know, and when you see sort of conflicting provisions here giving the minister great discretion in other acts. Well, the third topic that I want to touch on are special types of letters of administration. Now this is the portion of the paper which I will attach the precedents to when the paper is published. And I only raise these because I have found over the years of practice that you can run into these difficult situations. Letters of administration with will annexed. Section 53 of the Surrogate Courts Act governs the appointment of an administrator. And you're all aware of the types of situations where the executor may not be able to act or is dead or whatever. And so you might want to have letters of administration with will annexed issue. One of the places where this difficulty comes about is where there is a foreign executor. And foreign banks, you know, banks in the United States and in England can act as executors. We cannot issue ancillary grants to foreign banks or foreign trust companies, and therefore an ancillary grant cannot be made by the Ontario court, and you must have someone appointed in Ontario for letters of administration with will annexed. And a bond must be filed. The court likes to try and get an affidavit of execution and use the exemplification from the foreign court. I refer to a number of cases there, but I'll skip those. A second one is letters of administration de bonus non administratus with will annexed. And we don't often see this, but there was a solicitor, may he rest in peace, who always had himself named the sole executor of wills. Never an alternate, always the sole. And unfortunately, he passed away and left a number of estates with the administration not completed. And so everybody's left with the problem of having to get letters of administration de bonus non administratus with will annexed. And the difficulty, of course, the beneficiaries, under the surrogate court rules, the beneficiaries can make the application and so forth, but it becomes an added expense, especially when he didn't keep any proper executor's accounts, and you have to try and reconstruct those accounts. So let that be a lesson. Don't draft yourselves into wills as the sole executor. The third area is letters of administration pendente lite or lite. These are issued when pending the question of the validity of a will. And again in the paper I point out the case law with respect to these and the way the courts have evolved. I want to simply draw your attention to the recent court case of Reed Lloyd. It's a 1979 24 Ontario report case, since it's one of the few up-to-date reported cases in this area. The widow made an application for an order appointing an administrator pendente lite for her husband's estate. And the assets consisted mainly of shares in a private company. There were two conflicting wills, caveats filed, everybody fighting. And the son who was looking after the private companies was an executor named in one of the will. The court held that it should not exercise its discretion to appoint such an administrator unless the grant is necessary to preserve the property of the estate. So that seems to be the key, and that's the recent case. I've set out a procedure for you in the paper as to how you should go about getting the appointment because it involves a number of steps and a number of documents. And the last topic, and I see by my handy calculator time clock that I'm rapidly going over the time, so I'll quickly mention the interests of infants in estates, because here we have very little written in any of the textbooks, and this is just practical bread and butter information. One of the difficulties, of course, is how to deal with the assets of infants. Where the infant is a beneficiary under an estate and there is no will, or the will provides no power, there is procedure under the Trustee Act, of course, to pay the proceeds into court. And in my view, that's the careful thing for any trustee to do. One of the problems comes about, though, where the infant is residing in Ontario and the assets are out of Ontario. There is a conflict of laws problem between the province of Quebec and the province of Ontario regarding an infant's interest. In the province of Quebec, the parent or guardian can sign off a release and so forth on behalf of the infant. And they have a system called tutors in Quebec. But it is my understanding that the executor in Quebec can simply hand the money over to the notary who administers the estate to be held for the infant. And in my view, the money should be paid into court in the province of Ontario, where the infant resides. In my view, the law of the domicile of the infant should govern, since the parent in Ontario has no authority to give a receipt for the money coming in from Quebec. So you can solve that situation by making an application to the court to have the money paid into court, and the official guardian is very cooperative in obtaining court fiats which are acceptable to the notaries in Quebec, allowing the money then to come into Ontario and be paid into court. And in that way, the assets are protected. Another problem comes about where the infant resides out of Ontario and the assets are in Ontario. And the famous case that I've had to deal with was the case involving insurance proceeds, where the deceased was resident in Ontario, was murdered by his common law spouse, who was the named beneficiary of the insurance proceeds. So by law, by operation of law, she disentitled herself to the insurance proceeds. She was indicted and so forth. The beneficiaries then became his infant children who resided in Malaysia with their mother. And strangely enough, the applicant for letters of administration was the deceased mother in Newfoundland. But the assets were in Ontario. The insurance policies were taken out in Ontario, payable in Ontario. And so we had a reseal of letters of administration from Newfoundland. And then we applied under the Trustee Act to have the monies paid into court to the credit of the infant children in Malaysia, but being held by the court in Ontario, because that was the only way the insurance companies could validly release the monies. One of the things that people seem to forget is that even though someone is appointed a guardian of an infant under the Infants Act, that guardian has no inherent right to take the insurance monies that belong to a child. What the guardian has is the right to administer the income, take the income, or administer the income, or administer other assets which the child might own in his own right. So that if the insurance policy does not name a trustee for the infant, then in my view, the insurance company has no other choice but to pay the money into court. Now, there are some solicitors who would disagree with me, but there's another case, another Lloyd case I refer you to, and this one is a 1949 case that I think makes it very difficult for the insurance company not to pay the money into court. And so those are some of the practical problems, and I have now gone at least 5 minutes over. Have a short coffee. Thank you.